This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to talk about the infamous Vermont Supreme Court decision that allegedly allowed for coverage for business interruption under a COVID claim. To be honest, Vermont did not find coverage. Vermont's ruling in favor of an insured seeking business interruption coverage due to COVID is a Pyrrhic victory. In Huntington Ingalls Industries et al. Versus Ace American Insurance Company et al., a September 23, 2022 decision of the Supreme Court of Vermont reversed the decision of a trial court that refused to allow an insured shipbuilder to recover business interruption losses as a result of government orders dealing with COVID-19, and the Supreme Court remanded the case to the trial court to determine if COVID caused direct physical damage to property. The insured Huntington Ingalls and its insurer Huntington Ingalls Industries Risk Management, LLC, survived the dismissal of their case seeking coverage under a property insurance policy for certain losses incurred by Huntington Ingalls Industries due to the pandemic. The insured is the largest military shipbuilding company in the United States and provides professional services to government and industry partners. It employs over 42,000 people, the majority of whom work in shipyards in Virginia and Mississippi. In March of 2020, the insured purchased a property insurance policy from the insurer Huntington Ingalls LLC, its captive insurance subsidiary, and a Vermont corporation, therefore bringing the case in the state of Vermont. The policy covers the period of March 15, 2020 to March 15, 2021. That same month, the insurer purchased policies from multiple reinsurers to reinsure all its obligations to the insured under the global policy. Each reinsurer participated for a specified percentage of the reinsurance program. Reinsurers' policies incorporated the global policy by reference, stating, for example, that their liability shall attach simultaneously with that of the insurer and shall be subject in all respects to the same risks, terms, conditions, rates, interpretations, and waivers of the underlying policy issued to the insured. The policy, titled Global Property Insurance, contains relevant provisions that all real and personal property are insured against all risks of direct physical loss or damage to property. In the business interruption clause, it covers loss due to the necessary interruption of business conducted by the insured, whether total or partial, caused by physical loss or damage insured herein, close quote. Recovery under the business interruption provision is limited to the extent that the insured is wholly or partially unable to produce goods or continue normal business operations or services during the period of recovery, or be unable to make up lost production within a reasonable period of time, or C, able to demonstrate a loss or reduction of net profit for the services or production prevented, impaired, or interrupted. The period of recovery begins on the date of loss or damage and shall not exceed such length of time as would be required with the exercise of due diligence and dispatch to rebuild, repair, or replace the property that has been destroyed or damaged. The period of recovery also includes such additional length of time to restore the insured's business to the condition that would have existed had no loss occurred. The policy provided also that Vermont law covers the construction of its terms. Now, SARS-CoV-19 is a virus that causes disease, COVID-19. In March of 2020, civil authorities across the United States began to issue orders requiring certain businesses to close and recommending people stay home to reduce the virus's spread. Civil orders generally required businesses to adhere to social distancing, employ enhanced sanitization practices on surfaces, and follow recommendations from the Centers for Disease Control and Prevention and state health departments. However, they allowed businesses to operate at a level needed to provide essential services, such as the shipyard. The Insured kept its shipyards open but made changes to its operations to comply with CDC guidance and protect its employees. In September of 2020, the Insured and insurer sued the reinsurers, seeking a declaratory judgment that they are entitled to coverage under the policy for property damage, business interruption, and other losses suffered as a result of the pandemic and civil authority orders. The complaint alleged that pandemic caused direct physical loss or damage to property when the virus adhered to surfaces for several days and lingered in the air for several hours at the shipbuilding yards. The trial court granted the reinsurer's motion for judgment on the pleadings and consequently denied all of the insured's motions. The inquiry focused on the meaning of direct physical loss or damage to property under the policy as interpreted by the Vermont Supreme Court. An insurance policy in Vermont is construed according to its terms and the evident intent of the parties as expressed in the policy language. Terms in an insurance policy are interpreted according to their plain, ordinary, and popular meaning and will enforce unambiguous terms as written. When the Supreme Court of Vermont looked to determine if an insurance policy's undefined terms have a plain meaning, well, it usually and frequently refers to dictionary definitions. First, it found that the phrase direct physical loss concludes with to property, and this is a property insurance policy. Thus, the analysis is framed with a focus on what is happening to the insured property. The centrality of property to this insurance policy requires that something must occur affecting personal or real property for direct physical loss or damage to property to occur. Although all risk policies are generally construed in favor of coverage, risk and loss are distinct concepts. The Supreme Court concluded that direct physical damage requires a distinct, demonstrable, physical change to property. When it combined the definitions of direct, physical, and damage, the plain meaning became evident. However, a distinct, demonstrable physical alteration need not necessarily be visible. Alterations at the microscopic level may meet this threshold. In that regard, the Supreme Court considered a case called Ashland Hospital versus Affiliated FM, a 2013 decision of the Eastern District of Kentucky, where the United States District Court concluded that disk drives altered on microscopic level due to heat exposure causing decrease in reliability constituted direct physical loss or damage to the insured property. That definition is consistent with the policy section on the period of recovery, which defines the time for which business interruption claims may be made. The insured may make a business interruption claim under the policy for the period starting with the date of the coverage triggering event and not exceeding the time needed to rebuild, repair, or replace the damaged property and such additional time is needed to restore the insured's business to its pre-loss condition. In order for something intangible to cause a direct physical loss, the cause of loss must be so persistent as to require intervention rather than the mere passage of time to satisfactorily address it. The insurance policy in this case, according to the Supreme Court of Vermont, is unambiguous and must therefore be afforded its plain meaning. The phrase direct physical loss or damage to property includes two distinct components, each of which will trigger coverage unless an exclusion applies: direct physical damage and direct physical loss. Direct physical damage requires a distinct demonstrable physical change to property. Direct physical loss means persistent destruction or deprivation in whole or part with a causal nexus to a physical event or condition. Purely economic harm will not meet either of these standards. In applying the plain meaning of the policy language as interpreted in this case, the insured has the burden of proving that the losses it alleges are either direct physical loss or direct physical damage to property. On remand, therefore, the trial court must allow further factual development consistent with the philosophy underlying notice pleading, although the science, when fully presented, may not support the conclusion that presence of a virus on a surface physically alters that surface in a distinct and demonstrable way. It is not the Supreme Court's rule at this stage in the proceedings to test the facts or the evidence. To be clear, the opinion does not state that what occurred in the insured's shipyard is direct physical loss or damage to property under the policy. The Supreme Court merely concluded that the insured has alleged enough to survive a motion to dismiss. The Supreme Court concluded that the insured's complaint contains sufficient allegations to survive a motion for judgment on the pleadings under Vermont's extremely liberal pleading standards. Justice Carroll dissented and stated that as a matter of law, in his opinion, human-generated droplets containing SARS-CoV-19 cannot cause direct physical loss or damage to property under this insurance policy. No further litigation can change that reality. While I agree with the majority's conclusion that the insurance contract term in dispute is unambiguous, I cannot agree that the insured's claim survives beyond the pleadings stage. In my opinion, the news stories about Vermont giving the first victory to an insured seeking business interruption coverage for losses resulting from COVID-19 orders, the opinion was exceedingly long and dealt with definitions and interpretation of insurance policies and the liberal pleading standards in the state of Vermont. The essence of the decision was that the insureds alleged sufficient facts in their lawsuit to avoid a motion to dismiss, but must now go to the trial court and produce evidence and science that the virus actually caused direct physical damage to the property of the insured, something courts across the country have found that does not happen, cannot happen, and did not exist. So this is really just a pleadings case, and the evidence that will be produced at trial may be interesting, but probably very difficult to carry the day. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link at zalma.com/blog and where you can subscribe to receive daily blog postings, and you can also subscribe to these videos at rumble.com and on youtube.com. If you found this video and blog posting to be interesting and useful to you, please tell your colleagues and friends so that they can also view these videos, read the blogs, and subscribe. You might also wish to subscribe to my Substack publications and my locals community, where you can get many videos in the Excellence in Claims Handling program. Thank you for your attention.